The Finnish trial. Prosecutors have an obligation to bring a criminal charge if the evidence supports it, except in some circumstances, like the charge is de minimis or insignificant. Victims are parties in criminal cases. They get to attend, they get to be represented by counsel, they participate. If the public prosecutor doesn't bring a prosecution, the victim can bring it anyway. If the victim does bring it without the public prosecutor and loses, they pay costs. So they build in a disincentive for frivolous victim-initiated prosecutions. There is no plea bargaining in Finland. In fact, it strikes them as odd in a way that we have it. There is no way to adjudicate guilt other than by trial. Now, a confession of guilt would simplify the trial radically. It becomes not very hard to convict if the defendant is confessing guilt. But there's no way to avoid trial and adjudicate somebody. They have no jurors, but they have what's called lay judges, who are people appointed by sort of municipal officials for 4-year terms, and they have other jobs. They come in a couple of times a week for a day, or a couple of times a month maybe, to sit on trials. And so there'd be often a professional judge, a legally trained judge, and 4 lay judges who deliberate together. They hear the evidence, they deliberate on the law and on the facts. Finland doesn't have rules of evidence in the sense that we have them. They have a principle called free evaluation of evidence. I think the thing is, if you don't have jurors, you don't really need rules of evidence in the same extent, because the judges are presumed to be able to give the appropriate discount to flawed evidence, like hearsay. Presumed to be able to disregard prejudice, and yet extract from what would otherwise be prejudicial information its probative nucleus. Civil claims are co-adjudicated with criminal claims. I watched a trial while I was there where it's a complicated scenario. There'd been sort of kind of a home invasion, beat down, and then somebody came back and went after the perpetrator of the first crime and beat him up separately in a second event, and the whole thing was tried together. Defendant in the first case was the victim in the second. There were civil victims who had civil claims to be brought in this case. They're all there in the courtroom at the same time. So that's trial. Oh, one more thing about trial. At the end of the trial, the professional judge and the lay judges deliberate. They produce a written explanation of their verdict.